Viewers and listeners, welcome to the weekly episode of the Carbone Lawyers Law Lab podcast. My name's Tony Carbone. I'm the managing partner of Carbone Lawyers. With me, I've got Elio Mirabella, the People and Culture Manager at Carbone Lawyers. G'day, Elio. How are you?
Good, you?
And Marin Carlos, an associate at Carbone Lawyers in work cover and litigation in general. G'day, Marin. How are you?
Oh, good, Tony. Yourself?
Yeah, good, thank you. Viewers, we've got a very important episode. We're discussing workers' rights and the duties of employers in relation to employment contracts, how it interacts with work cover, and how do people protect each other, protect themselves. One of the things that was pretty significant about what happened recently, Elliot, was this federal court decision on casual employees. In short, what did the federal court say?
Tony, effectively, the casual employee got the same rights as a permanent employee in the fact that they now will have leave, annual leave,
sick pay,
etc.
Yep. Now, Marin, I thought there was a leave loading paid to casuals to cover off on those things.
Yeah, so look, there was two decisions. The first decision is Skeen, which had a two decision in itself. There was a 2016 decision and a 2018 decision, and that was affirmed in the recent decision of Workpac and Rosado.
Well, okay, seeing you've raised that, what were the facts of Skeen?
Skeen. So Skeen was a individual who worked for a mining company or worked for a labour hire company who was sent to mining companies. He was on a fly-in, fly-out basis. He was provided his rosters a year in advance. So
he knew what he was doing. He was not, strictly speaking, wasn't really a casual.
That's right, and those two cases speak about what is a casual employee and what is not. So it provides a really good discussion as to the indicia of casual employees.
Look, just on that, Elio, I found that in recent times I've been getting a lot of inquiries. People are saying to me, "Oh, look, my employer says that I'm a casual." But then when they talk to me about the hours they're working the same hours every week.
Yeah, I think that's the key, Tony. I think it's about if you're working systematic hours, regular hours over an extended period of time, let's say 12 months, I think it'd be fair to say if you're an employee in that situation, you could argue that you're actually a permanent employee.
You're a permanent.
Which, again, you get those rights that a permanent employee would have.
And what was very interesting about that, Tony, is there was a leave loading or casual loading, applied to Skeen and Rosado, but the key issue in that case was the casual loading was not separated in the payslips. So essentially, he was provided.
That's tricky.
Yeah. So, and that's where they got stuck.
Well, that's double dipping, really, if you think about it.
In some respects,
he's getting the casual loading in addition to now receiving the leave entitlements.
Yeah. So look, it could be seen as double dipping, but the federal court said, no, it's not double dipping, considering that there was one set hourly
Just on
rate.
the back of this case, I had an inquiry during the week where someone that's been working for 17 years in very similar circumstances where they're doing the same thing week in, week out, all of a sudden saying, hold on a minute, I'm entitled to holiday pay, sick pay, and all the other benefits that go, and superannuation, which is not insignificant, correct?
Absolutely, that's critical. Like if, and that's where sham contracting comes into place, I suppose.
What's sham contracting, Elliot?
Well, some businesses might engage a person, a contractor, so to speak, that has an ABN, and use them in that effect, but ultimately they're really being used as an employee. And sometimes it's been alleged that businesses use that scenario as a way of not to pay superannuation and to leave entitlements, etc.
And just on that, Marin, we've got a lot of cases involving couriers, for example. They've been told to supply their own vehicles, their own insurance, but at the end of the day, they don't work for anyone else.
And I think that if you're receiving direction from an employer or a business, it's fair to say that you're an employee.
It's a control test.
It is, and there is a famous case of Sharif and Alizak, which really sets out what the indicia is for an employee. So in those circumstances, we look at what the common law principles are as to what constitutes an employee and employer, very similar to the federal court decision in which the indicia of what constitutes a casual employee as opposed to a genuine permanent employee.
Look, it's a very interesting thing because I've got to be quite frank. With a lot of the people I've seen over the years, I'd say a lot of them, even though they're classified as contractors / casuals, I would argue and have in many instances argued that they're permanent employees.
I agree.
And in very few cases have we not succeeded in proving that.
Of course. And becoming a permanent employee and, you know, if you're injured in the workplace, you are entitled to workers' compensation benefits. And you'll find that insurers in those circumstances hang their hat on the fact that you are not a permanent employee.
That you're a contractor.
And you're a contractor.
So we've got deeming legislation under our Fair Work Act and also the Workers' Rehabilitation Act, which deals with workers' comp in Victoria. There's deeming provisions.
That's right, Tony.
And more often than not, the courts do deem in favour of the worker.
Yep, that I could understand.
You know, employees hang their hat on, oh, look, I've got a little contract saying you're an independent contractor. But bottom line, you look at all the different parameters, as you said, Marin, and then you start going through them one by one and you work out this guy's just another permanent employee.
That's right.
Correct?
That's right. So the courts have always said, look, we don't look at the contract. We prefer substance over form, so to speak. So we do look at the whole relationship in total. So look, I urge anyone with any queries about that to contact Carbone Lawyers. We've got some experts in this field. Tony will take care of you.
Can I say this, viewers? One of the things I found really critical is that in a lot of instances involving these issues about pay, more often than not, there's also bullying attached to it, isn't there? Intimidation, bullying, harassment. So there seems to be a massive overlap between any wage disputes and also work cover rights. Have you noticed that?
Yeah,
I mean,
absolutely.
It happens a lot. Do you agree, Al?
Absolutely.
And just on that point that Marin just raised, viewers, one of the important things is that fortunately we've got a lot of people with, I mean, from the HR perspective, I mean, Elio, you've been around doing this, I don't know how many years.
Yeah, a long time, over 10 years.
And the rest. And I mean, you know, heading up a children's hospital and also working at the Royal Melbourne, CSR, and you also had that experience with the security company.
Yeah, with MSS.
I mean, it's so critical that you got people around you that really understand how the whole thing works. Isn't that right, Marin?
Absolutely.
And so an overlap between the Fair Work Act and the workers' comp legislation, and then you marry the two together, and you'll find that all of a sudden your rights are improved out of sight.
Absolutely.
Because if you've got the right people looking after you.
Absolutely.
And I think another thing I'd like to point out in terms of, you know, all these changes that are occurring in the Fair Work Act, etc. Last year, the Fair Work Commission undertook a review of all modern awards, and there's additional obligations on employers now in order to comply with modern awards. So if you're an employee covered by a modern award, there are some changes that it's very important that you're aware of. So please give us a call and we'll be able to help you and give you the right advice.
And Marin, what I'm finding is that in the year 2020, you know, once upon a time, you and I probably saw a lot of RSI type claims, et cetera, et cetera. Geez, I'm seeing a lot of bullying, Al. A lot of bullying, harassment, intimidation. And mind you, with this whole thing around COVID-19, aren't we having a situation where employers are probably reevaluating their needs? A lot of them, you know, have been financially hamstrung, and they're in a situation where, look, they're going to have to do cutbacks.
Yep.
Right? So, you know, in some instances, I found that there's intimidation and harassment, so that people get up and leave.
Yeah, absolutely. We're finding a lot of injuries these days are the psychological, psychiatric injuries. And it is really when a restructure occurs that those decisions as to who leaves and who stays is made based off the previous employment history.
Let's have some live examples, right? You had one recently, didn't you, Marin?
Yes, I did. So I received an inquiry from a lady who suffered a psychological injury in the workplace due to bullying and harassment, and she went on maternity leave, okay, and her return to work plan was supposed to be working under the same manager, okay. All the medical evidence came back and said, no, she cannot work under this manager, she can return to work. And this is where employment law and workers' compensation interact. the employer actually said, we don't have any more work for you after coming back from maternity leave. So that turned into a general protections claim and also a workers' compensation claim in the background and proceeds as usual. So in that case, we were able to negotiate a settlement figure for her, and we are continuing on with her workers' compensation claim.
Just on that, Marin, this general protections right under the Fair Work Act, Anelio, the employers aren't insured for that. That, as a rule, that comes out of their pocket. So they've got to be really careful these days, don't you think?
Absolutely. And this is coming out of the back pocket of the employers.
And I've found that, one of the examples I got the other day, what's still going on in 2020? Swearing and carrying on and belittling people in a workplace.
Yeah.
If you've got to make a point, you don't do it in front of other people because that's when you're exposed. If you want to, look, let's be realistic. You're an employer. You've still got to be able to talk to your employees and bail them up when they're not doing the right thing. But there's a way of conveying a message, and you don't do it by belittling them and embarrassing them in front of a group. Absolutely. That is classic bullying.
Absolutely. Times have changed. These days you treat your staff with respect, you earn goodwill in that regard.
Or treat people the way you'd like to be treated.
Correct. Absolutely. It's not hard. It's just, unfortunately, some aren't very good at it.
This is at all employers. Because bottom line, once you're hailed or bailed up as a bully, it makes it pretty hard for you to get a job.
Yeah.
Don't you think?
Absolutely.
Hey, Elio, what about the example you had recently where because of his COVID-19 business, a lady, they said they were restructuring, but
correct.
Effectively they were only restructuring one job.
Yeah, correct. She'd been an employee there for 25 years. And, they, undertook a restructure, proposed to undertake a restructure, impacted her. She contacted us for some advice. We gave her some advice and ultimately...
She went back to management, obviously.
She went back to them, provided that feedback to them, and they pulled the pin on the restructure. So,
it wasn't a genuine restructure. No. You're restructuring one job.
I think it goes to your point earlier, Tony, that, maybe some employers, unfortunately, will use the COVID-19 as an excuse.
I guaranteed. Look, I'd hate to say it. There's going to be a lot of people out there that think, one, we don't need rental premises. Mm-hmm. Two, we don't need as many staff. So, look, realistically, sadly, the balance of power is going to be shifting now. Because, see, a lot of employers are going to do this based on the fact that it comes back to what they can afford. Because, this would have eaten deeply into the pockets and reserves of a lot of companies, correct?
Absolutely.
Mm-hmm. If you have a look at even, for example, the sporting clubs, the NRL have said that by the end of the year, they're going to be broke. And Geelong Football Club are going to the commission already saying, by the end of the year, we've got no money. We've got a real major problems coming up in the future around money, finances, relationships, the whole box and dice.
Which it was really important that employees understand their rights.
Of course. Mary, anything else you'd like to add? We've come to the end of the episode.
Look, Tony, I just wanted to touch upon what an employee has the right as well in these circumstances to make a request for flexible working environments, and that has to be considered by the employer. So I encourage those who have predispositions in this current climate to serious health issues to contact their employer. It's a common sense approach. Contact your employer. Your employer has 21 days to respond to that.
And at the moment, you've got government backing too, haven't you?
Absolutely, yeah.
Elio, anything else you'd like to add?
No, just if you're an employee working in a casual arrangement, have a look at your circumstances, have a look at the regularity of the work you're doing, and if it's consistent and systematic, you might have
permanent.
You might be, claim for permanency.
You got yourself 3 or 4 months of holiday leave owing to you.
Yep.
That's right.
So you can get...
Big deal.
And long service accrues as well.
Yep.
It's amazing. Anyway, guys, thanks for coming on board. Viewers and listeners, thanks for watching. Stay tuned for future episodes. Go to our social media platforms and please always remember to stay safe.